Imagine for a moment you're navigating a truly complex international commercial dispute. Parties span different continents, the contractual terms are a legal minefield, and the financial stakes are incredibly high.
Hmm.
How do you ensure a fair, efficient, and most importantly, enforceable resolution outside of traditional national court litigation, which can often feel like, a roll of the dice across borders?
That's the exact challenge, isn't it? And it's right at the heart of our deep dive today. We're stepping into the intricate world of international dispute resolution, specifically focusing on the foundational legal blueprint designed for these very scenarios, the UNCITRAL model law on international commercial arbitration.
And we're zeroing in on those pivotal 2006 amendments, right? The ones that really brought it up to date.
Exactly. Those amendments were crucial for modernizing its approach, making it fit for purpose in the 21st century.
Now, this isn't just a basic overview. Our mission here is to really take this essential legal instrument, unpack its core provisions, and then conduct, well, an in-depth legal analysis.
Right. We want to get into the weeds.
We're going to explore its theoretical underpinnings, dissect its practical and judicial applications, and even look at the sort of underlying assumptions behind some of its key provisions. We'll evaluate their consistency with broader legal principles, explore exceptions, consider alternative interpretations.
And tackle those tricky ambiguities and overlaps, the things that often challenge even, seasoned legal professionals in practice.
Precisely. This is about elevating your professional competency and sharpening your critical legal reasoning in international dispute resolution.
The goal is for you to walk away with a comprehensive understanding that goes far beyond a typical summary, something that enables you to confidently advise your clients, draft more robust arbitration clauses, and, frankly, anticipate challenges in the ever-evolving landscape of international commercial arbitration.
Get ready for some serious aha moments, the kind that can directly impact your practice.
Hopefully.
So let's set the stage. Before UNCITRAL, before this model law, what did the landscape of international commercial arbitration even look like? Why was a unified framework so desperately needed?
That's the crucial starting point, because the model law didn't just appear out of thin air. Before UNCITRAL stepped in, the international arbitration world was, well, frankly, it was a chaotic patchwork.
A patchwork.
Yeah, you had this myriad of diverse national laws governing arbitration, and many of them were simply inadequate or wildly inconsistent. It created significant headaches, real legal uncertainty for businesses trying to operate across borders.
Okay, when you say inadequate, what specifically were the core issues with these domestic laws?
Yeah.
What kind of practical problems did they create for parties trying to arbitrate an international dispute?
Well, imagine a sophisticated international contract. The parties painstakingly negotiate an arbitration clause, maybe agreeing on specific rules like the UNCITRAL arbitration rules.
Right.
But then, to their surprise and, frankly, frustration, they discover that the local national laws at the place of arbitration were imposing, undesired requirements or even directly overriding those carefully chosen arbitration rules.
So the local law could just trump the parties' agreement.
In some cases, yes. For instance, some domestic laws had mandatory provisions that restricted what disputes could even be submitted to arbitration in the future, maybe saying you couldn't agree to arbitrate future disputes.
Okay.
Or they might dictate exactly how arbitrators had to be selected, taking away the parties' freedom. Or they might even disregard the procedural rules the parties had carefully crafted for their own proceedings, imposing local court-like procedures instead.
Wow. So even a perfectly drafted arbitration agreement could be completely undermined by the local law of the place of arbitration. That sounds like a huge source of uncertainty for anyone doing international business.
It was a massive source of uncertainty, and it wasn't just about restrictive mandatory rules. Sometimes non-mandatory provisions, default rules, would impose undesired requirements simply because the parties, maybe unfamiliar with that specific local law, didn't think about the need to provide otherwise in their agreement.
They just assumed their agreement would govern.
Exactly. They assumed their chosen rules would apply. And worse still, in many cases, there was simply an absence of any legislative provision for many crucial procedural issues unique to international arbitration. This left critical gaps that could lead to delays, confusion, or even outright disputes about how the arbitration should proceed.
So for any legal professional advising a client on an international deal back then, this fragmented landscape was a genuine minefield.
A minefield is a good word for it. You were constantly worried about the local law tripping you up.
And beyond the inadequacy of individual national laws, you mentioned the problem of their disparity. How did these wide differences between national laws complicate things further?
The disparity was a frequent source of concern, absolutely. Think about the practical difficulties. It was often incredibly expensive, impractical, or impossible to obtain a full and precise account of the law applicable to the arbitration when you were dealing with multiple foreign and unfamiliar legal systems.
You'd need local counsel in potentially several jurisdictions just to understand the procedural framework.
Precisely. Imagine having to get expert opinions on half a dozen different national arbitration laws just to understand the potential pitfalls of your client's arbitration agreement. This sheer unpredictability, this lack of harmonization, adversely affected the functioning of the arbitral process itself.
And I assume it had a direct impact on a really critical strategic choice, the selection of the seat of arbitration.
Absolutely. That uncertainty directly influenced the selection of the place of arbitration. Parties would naturally hesitate and often actively avoid choosing a location if its legal framework for arbitration was unpredictable or unfamiliar, even if that location was geographically or logistically ideal.
They'd stick to the few places they knew had a reasonably stable arbitration law.
Right, which limited choices and potentially disadvantaged parties who might have preferred a more convenient or neutral location. The model law was really designed to create a global standard, to level the playing field, thereby expanding the pool of reliable seats for international arbitrations.
Okay, so UNCITRAL steps in with a solution. And it's interesting, they didn't go for a binding convention like the New York Convention, which might seem like the obvious choice for harmonization. They opted for a modern law. What was the strategic thinking behind that choice?
That's a really astute point because the choice of a model law was indeed highly strategic. A model law offers crucial flexibility to states. It's essentially a template, a well-thought-out blueprint that national legislatures can adopt and integrate into their existing legal systems.
So it's less prescriptive than a treaty.
Much less prescriptive. It avoids forcing states to ratify a rigid, potentially controversial international treaty. This approach respects the diversity of legal traditions and sovereignty around the world, making adoption politically easier.
But there's a bit of a paradox there, isn't there?
Yeah.
They offer this flexibility, this freedom to adapt it, but then essentially encourage countries not to change it too much.
Exactly. It's a very subtle but powerful form of encouragement. While offering flexibility in adoption, UNCITRAL strongly encouraged states to make as few changes as possible when enacting the model law into their national legislation.
Why? What's the goal there?
The core reason was to maximize the visibility of harmonization. If many countries adopt the model law with minimal changes, it creates a recognizable, largely uniform legal framework across borders. This, in turn, helps enhance the confidence of foreign parties.
So if a business sees that a country's arbitration law is based on the UNCITRAL model law, they have a much better idea of what to expect.
Precisely. They immediately understand its foundational principles, its basic structure, how courts will likely interact with the process. It builds trust and predictability, which are absolutely essential for facilitating international trade and investment.
So when did this blueprint first emerge? Let's talk about the 1985 genesis.
The foundational genesis of the model law was back in 1985, stemming from UN General Assembly Resolution 4072. This resolution was really a landmark moment. It explicitly recognized the value of arbitration as a method of settling disputes in international commerce and stressed the importance of creating a model law acceptable to states with different legal, social, and economic systems.
And its goal was pretty ambitious.
Incredibly ambitious for the time. Its foundational goal was to contribute significantly to the establishment of a unified legal framework for the fair and efficient settlement of disputes arising from international commercial relations. It was about creating order out of that chaos we discussed.
And it wasn't developed in a vacuum, was it? It fits into a broader UNCITRAL ecosystem for international arbitration.
Absolutely not. It was deliberately conceived as complementing the existing pillars of international arbitration. Most notably, the 1958 New York Convention on the Recognition and Enforcement of Foreign Arbitral Awards.
The bedrock of award enforcement.
The absolute bedrock. Without the New York Convention, international arbitration wouldn't be nearly as effective. And the model law also complemented the 1976 UNCITRAL arbitration rules, which provide a detailed set of procedural guidelines that parties and tribunals can choose to adopt for conducting their arbitrations.
This is part of a family of instruments.
Exactly. This interconnectedness is crucial for appreciating the model law's comprehensive role in the international dispute resolution landscape.
Okay, now let's fast forward to 2006, which is a major focus for us today. The 2006 amendments, driven by General Assembly Resolution 6133, represented a significant modernization effort. What necessitated these changes? What had evolved in the global commercial world since 1985 that made these updates imperative?
Well, a lot had changed in those 2 decades. The amendments were a direct response to current practices in international trade and modern means of contracting. Think about the explosive growth of electronic commerce since the mid-80s.
Right, email, EDI, online contracts.
Precisely. The speed of global transactions had increased dramatically, and there was a growing need for more agile and effective dispute resolution tools. Specifically, 2 areas became particularly pressing and were, frankly, lagging behind business reality.
For sure.
First, the formal requirements for arbitration agreements, especially the in-writing requirement inherited from the New York Convention, which often clashed with digital contracting practices. Second, the power of arbitral tribunals to grant interim measures needed more teeth. It needed to be clearer and more enforceable to be truly effective in protecting parties' rights during the arbitration.
So it wasn't just a technical tweak like fixing typos, but a real strategic recalibration to keep the model law relevant and effective.
Exactly that. The objective was profound: to significantly enhance the operation of the model law and, importantly, also to promote uniform interpretation and application of the New York Convention itself, especially regarding that tricky form requirement in light of new technologies.
And for legal professionals, what did this mean practically?
It meant ensuring that your clients' e-contracts, with their digitally embedded arbitration clauses, could actually stand up to scrutiny and be enforced. And it meant you could more effectively seek urgent relief from the arbitral tribunal itself to protect your client's interests during an ongoing arbitration, like freezing assets or preserving evidence, rather than always having to run to national courts, which could be slow or unpredictable.
Got it. And before we dive into the specific articles, we should quickly mention the explanatory note that accompanies the model law. What its status and role?
Yes, the explanatory note. It's part 2 of our source material, prepared by the UNCITRAL Secretariat. It's technically an unofficial commentary, meaning it's not legally binding like the model law articles themselves.
Well, it's still important.
Hugely important. It offers crucial insights into the model law's intent, its drafting history, the policy choices made, and its practical application. For legal professionals trying to understand a specific provision, the explanatory note is often the best guide to understanding the why behind the text. It provides essential theoretical and practical context.
So definitely worth consulting.
Absolutely. Ignoring it means you're missing a key interpretive aid.
All right, with that foundational context firmly set, let's transition into part 2, the core principles and scope of the model law. Article 1 defines international commercial arbitration. And it gives international quite an expansive definition, doesn't it? Let's break that down.
It absolutely does, and this broad definition is fundamental to the model law's wide reach and applicability. The primary test for internationality found in Article 1.3a is quite straightforward. An arbitration is international if, at the time the parties concluded their arbitration agreement, they had their places of business in different states.
That probably covers the vast majority of cases we think of as international disputes.
It captures the bulk of them, yes. But the model law doesn't stop there. It recognizes that internationality can arise in other ways.
Right, those expanded criteria in Article 1.3b, what do they cover?
That's where it gets interesting and reflects a more nuanced understanding of international commerce. Article 1.3 broadens the scope significantly. An arbitration is also deemed international if one of several key places related to the dispute is outside the states where the parties have their places of business.
Such as?
Such as the place of arbitration itself, the seat, if it's agreed to be in a different country, or the place where a substantial part of the commercial relationship is to be performed, or the place with which the actual subject matter of the dispute is most closely connected.
Yes. So even if both parties are, say, incorporated in the U.S., but the contract involves building a factory in Mexico and the arbitration seat is London, it could still be considered international under the model law.
Exactly. That's a perfect example. It recognizes that the physical location of the party's headquarters might not fully capture the true international character of a complex transaction or dispute. These nexus points provide alternative anchors for internationality.
And can the parties themselves even agree to make a dispute international, even if it might otherwise look purely domestic, based on those objective criteria?
They can, which is a powerful recognition of party autonomy, a recurring theme in the model law. Article 13C allows parties to expressly agree that the subject matter of the arbitration agreement relates to more than one country.
So they can effectively opt into the model law framework.
Yes. Even if a dispute might initially appear domestic under the other tests, the party's deliberate choice to characterize it as relating to more than one country can bring it under the model law's harmonized framework. This promotes certainty by allowing them to choose a predictable international regime if they prefer it over potentially less suitable domestic rules.
And what if a party has multiple places of business, or maybe none at all, like an individual consultant? How does the model law determine the place of business then?
Article 1.4 provides clear tiebreaker rules for those situations. If a party has more than one place of business, the relevant one is the one that has the closest relationship to the arbitration agreement itself.
Not the underlying contract.
No, specifically the arbitration agreement. And if a party doesn't have a place of business, then their habitual residence is used instead.
So this whole expansive definition, different states, key places outside, party agreement, the goal is really to broaden the model law's applicability and avoid tricky characterization fights under different national laws.
Precisely. It aims to cast a wide net, promoting consistency and ensuring that a broad range of disputes that have a genuine international dimension can benefit from the model law's harmonized framework. For legal professionals, this means you need to carefully analyze these criteria when determining if the model law applies to your client's situation. It might apply more often than you initially think.
Okay, so that covers the international aspect. What about commercial? Article 1.1 famously says the term commercial should be interpreted widely. What does that mean in practice?
The footnote to Article 1.1 is explicit here. It calls for a wide interpretation to cover matters arising from all relationships of a commercial nature, whether contractual or not. It's deliberately non-restrictive.
It's not just, say, sales of goods.
Oh, far broader than that. The model law provides an illustrative but explicitly not exhaustive list of examples to give a flavor of what commercial encompasses. It includes everything from standard trade transactions, distribution agreements, commercial representation or agency, factoring, leasing, construction of works, consulting, engineering, licensing agreements, investment disputes, financing, banking, insurance, exploitation agreements or concessions, joint ventures and other forms of industrial or business cooperation, and even carriage of goods or passengers by air, sea, rail, or road.
Wow, that's incredibly comprehensive. Covers almost the entire spectrum of business activity. What's the rationale for such an inclusive approach? Why not just rely on domestic definitions of commercial?
The rationale is, again, harmonization and avoiding pitfalls. Domestic legal systems often have very different, sometimes quite narrow or technical definitions of what constitutes commercial law or a commercial act. Relying on those could lead to inconsistent application of the model law.
So a dispute might be considered commercial in one country but not another, even if the model law was enacted in both.
Exactly. That would defeat the purpose of harmonization. This wide, autonomous interpretation of commercial ensures the model law's universal applicability across diverse commercial activities and circumvents potential technical difficulty arising from restrictive local definitions. It ensures the benefits of the framework aren't artificially limited.
Makes sense. Okay, let's move on to the territorial scope of the model law's application. Article 1.2 generally links the model law's applicability to the seat of arbitration. Can you unpack that rule?
The general rule in Article 1.2 is fundamental. The model law, as enacted in a given state, applies only if the place of arbitration is in the territory of that state. The place of arbitration here means the legal seat, the juridical home of the arbitration.
And why is the seat so important? Why is it the primary trigger?
The rationale is deeply embedded in international arbitration practice and theory. In most legal systems, the seat is the exclusive criterion for determining the applicability of national law to the arbitration procedure. It provides certainty. It tells you which country's procedural law primarily governs the arbitration, and crucially, which country's national courts have the functions of supervision and assistance over the arbitration, as detailed later in Article 6.
So the legal seat determines the governing procedural law and the supervisory courts. But we touched on this earlier. That doesn't mean the arbitrators and parties are physically chained to that location for the entire process, does it?
Absolutely not. That's a critical distinction for practitioners, and it's where the model law provides essential practical flexibility. Article 22 explicitly clarifies that the designation of the legal seat does not limit the arbitral tribunal's ability to meet at any place it considers appropriate.
So they can hold hearings anywhere.
Anywhere they deem suitable for hearings with parties and witnesses, for consultations among the arbitrators themselves, or even for inspecting goods, property, or documents. This flexibility is vital for international disputes where parties, witnesses, or evidence might be scattered across multiple countries. The legal seat remains fixed, but the physical activities can roam.
Okay, but then we have those really crucial exceptions to the strict territorial principle. You mentioned certain articles apply irrespective of whether the place of arbitration is in the enacting state or elsewhere. Which articles are these, and why do they get this special extraterritorial treatment?
This is a vital nuance that legal professionals must grasp as it significantly impacts strategy. The key articles designed to apply extraterritorially are Articles 8, 9, 17H, 17I, 17J, 35, and 36.
And the rationale. Why do these specific ones operate beyond the seat?
The fundamental rationale is function. These specific provisions deal with critical aspects of interaction between the arbitral process and national courts, particularly concerning the recognition and enforcement of key elements. The arbitration agreement itself, Article 8, court-ordered interim measures in support of arbitration, Article 9, 17J, arbitral interim measures, Articles 17H, 17I, and final arbitral awards, Articles 35, 36.
So for those things to actually work internationally, they need to have effect outside the country where the arbitration is seated.
Precisely. By their very nature, these elements must have extraterritorial effect to be useful and effective in the context of international arbitration. They ensure that the core pro-arbitration policies embedded in the model law, like compelling parties to honor their arbitration agreements, providing judicial support for interim relief, and enforcing arbitral decisions, are upheld globally by courts in enacting states, regardless of where the arbitration itself is physically seated.
So let's take a practical example. Say you're representing a client in an arbitration seated in London, but the opposing party has assets in New York, and New York has enacted the model law. What can you do in New York based on these exceptions?
Based on these extraterritorial provisions, a court in New York could, for example, enforce the arbitration agreement under Article 8 if the other party tried to sue in New York courts instead. It could potentially grant interim measures under Article 9 or 17J to protect those assets pending the London arbitration. And crucially, it could recognize and enforce an interim measure issued by the London Tribunal under Article 17HI, or enforce the final award issued in London under Articles 3536.
That dramatically enhances the effectiveness of the whole system, doesn't it? Providing real teeth across borders.
It makes the system vastly more robust and reliable for international businesses and their legal advisors.
This leads us nicely to another cornerstone principle of the model law, the careful delimitation of court assistance and supervision, often referred to as the principle of non-intervention. Article 5, with its famous negative definition, is absolutely key here. Can you explain that?
Article 5 is really the gatekeeper for court involvement. It states, quite starkly, in matters governed by this law, no court shall intervene except where so provided in this law.
Except where so provided. That's the crucial part.
Exactly. The underlying assumption here is profound and pro-arbitration. When parties choose arbitration, they are specifically seeking to exclude traditional court jurisdiction over the merits of their dispute. They prioritize the finality, expertise, and expediency potentially offered by the arbitral process. Unpredictable or unauthorized court interference would fundamentally undermine this choice.
That sounds like a pretty radical departure from older national legal systems where courts often had very broad inherent powers to supervise or meddle in arbitrations.
It absolutely is. This represents a deliberate, policy-driven shift away from those traditional approaches where national courts often had sweeping, sometimes ill-defined, supervisory powers. Article 5 acts as a clear legislative fence. It forces national laws based on the model law to explicitly list every permitted instance of court intervention on matters covered by the model law.
So it enhances predictability.
Dramatically. It increases predictability for parties and legal professionals, significantly reducing the risk of surprise or frustration from unexpected judicial interference. It sets a very clear and generally quite high boundary for judicial involvement in the arbitral process.
So where can courts intervene? The model law doesn't advocate for complete judicial isolation, but rather a carefully designated list of supportive and supervisory functions. Right.
Precisely. It's not about eliminating courts entirely, but defining their role constructively. The model law carves out specific, limited instances where courts can and should play a role, ensuring the arbitral process remains fair, effective, and ultimately enforceable. We can generally categorize these into two main types of designated court involvement.
Okay, what's the first category?
The first category comprises what we often call supervisory functions, primarily outlined or referenced in Article 6. These involve court assistance at critical junctures related to the tribunal itself, things like the appointment of arbitrators if the party's mechanism fails, Article 11, challenges to arbitrators' independence or impartiality, Article 13, and the termination of an arbitrator's mandate if they're unable to act, Article 14.
So keeping the tribunal properly constituted and functioning.
Exactly. It also includes court review of the tribunal's decision on its own jurisdiction under specific circumstances, Article 16, and crucially, handling applications for the setting aside of arbitral awards based on those limited grounds we'll discuss later, Article 24.
And Article 6 also requires states to specify which court handles these functions.
Yes, Article 6 mandates that each enacting state specifies the court, courts, or other authority competent to perform these functions. The idea here is to promote centralization, specialization, and efficiency. Ideally, having specific, experienced courts handle these specialized arbitration-related matters rather than any local court.
Got it. And the second category of court involvement, the assistance functions.
Yes, these are more supportive roles, helping the arbitration process work effectively. They include court assistance in taking evidence, which might be needed to compel testimony or documents from third parties, Article 27. Also, the crucial role of recognizing and enforcing the arbitration agreement itself, compelling parties to arbitrate, Article 8. Then there's the power for courts to grant their own interim measures in support of an arbitration, Article 9, 17J. And finally, perhaps most importantly for the outcome, the recognition and enforcement of the arbitral tribunal's own interim measures, Article 17HI, and its final awards, Articles 35-36.
So Article 5 draws a very bright line. If a type of court intervention isn't on these specific lists, and it relates to a matter governed by the model law, courts should generally stay out.
That's the critical takeaway for practitioners. It clarifies that Article 5 doesn't necessarily preclude court intervention on matters not regulated by the model law itself, for example. Complex issues like the consolidation of multiple arbitral proceedings or maybe disputes over arbitrator fees might fall outside its direct scope, depending on how a state enacted it. But on matters squarely governed by the model law, the list of permissible court interventions is intended to be exhaustive.
It's a carefully calibrated balance then.
Exactly.
Yeah.
It aims to protect the arbitral process from disruptive interference while ensuring necessary judicial support for its integrity and the enforceability of its outcomes. It's fundamentally about empowering arbitration, not hindering it, by providing predictable judicial guardrails.
Let's move now into Part 3, which dives right into the heart of the matter. The arbitration agreement itself. Its definition, its form, and how it interacts with national courts. Article 7 is particularly important here, especially given the significant changes introduced in 2006.
Indeed, Article 7 is absolutely fundamental. Without a valid arbitration agreement, there's no arbitration. The original 1985 version of Article 7 was intentionally drafted to be quite similar to Article 2 of the 1958 New York Convention.
Which required the agreement to be in writing?
Exactly. It required an agreement in writing and defined that fairly traditionally, involving signatures or an exchange of letters or telegrams. While this offered a degree of certainty at the time, it quickly became a bottleneck, a point of friction, with modern contracting practices, particularly with the explosion of electronic communications.
Yeah, I can easily see that. So many business deals now are done via email chains, electronic data interchange, web forms, things that don't fit neatly into the signed paper or telegram exchange model. What was the core problem the 2006 amendment to Article 7 sought to address?
The core issue was that in many contemporary business situations, obtaining a traditional written document signed by both parties might be impossible or impractical. Think about battle of the forms scenarios or contracts concluded rapidly via email. Yet, crucially, in many of these cases, the parties' actual willingness to arbitrate was not in question. Their intent to arbitrate was clear from their communications or conduct, but the rigid formal requirements of the old Article 7 could potentially frustrate that clear intent.
So the form was getting in the way of the substance of their agreement.
Precisely. The 2006 amendment to Article 7 was a direct, pragmatic response to this disconnect, aiming squarely at accommodating evolving practice in international trade and technological developments.
So how did UNCITRAL modernize this in writing requirement. It wasn't a single one-size-fits-all solution, was it? They actually gave enacting states options.
That's right, and this reflects UNCITRAL's typical approach, providing flexibility while promoting harmonization. They offered two distinct options for revising Article 7, allowing states to choose the approach that best fit their existing legal systems and policy preferences regarding contract formalities.
Okay, let's start with option I. This sounds like the more detailed, prescriptive approach, but still modernized.
Option I is indeed more detailed. It starts in Article 7.1 by defining an arbitration agreement, broadly, an agreement to submit present or future disputes arising from a defined legal relationship, contractual or not. Then Article 7.2 maintains the baseline requirement. The arbitration agreement shall be in writing.
Okay, so far so traditional. Where's the modernization?
The real innovation comes in Article 7.3. This provision dramatically reinterprets what in writing means. It states that an arbitration agreement is in writing if its content is recorded in any form, whether or not the arbitration agreement or contract has been concluded orally, by conduct, or by other means.
Hold on. Recorded in any form. Even if the agreement itself was oral or made by conduct, that's a huge shift, isn't it?
It's a massive liberalization. The emphasis shifts dramatically away from the form in which the agreement was concluded to simply ensuring that the content of that agreement, the agreement to arbitrate, is somehow recorded and preserved.
So the key is the record, not the initial method of agreement.
Exactly. As the explanatory note highlights, this means the law no longer requires signatures or an exchange of messages in the traditional sense for the agreement to meet the writing requirement, as long as its substance, the agreement to arbitrate, is captured and accessible. Article 7.4 then explicitly clarifies that electronic communication meets this definition, provided the information contained therein is accessible so as to be usable for subsequent reference.
And that covers email, EDI.
Yes, it adopts concepts directly from the UNCITRAL Model Law on Electronic Commerce, specifically covering things like electronic data interchange, EDI, email, telegram, telex, or telecopy, essentially any method that creates a retrievable record.
What about situations where there's no explicit written agreement, but maybe it's implied by the parties' actions or pleadings in a dispute? This option might cover that.
It does. Article 7.5 addresses this scenario, deeming an agreement to be in writing if it's contained in an exchange of statements of claim and defense in which the existence of an agreement is alleged by one party and not denied by the other. This covers situations where parties effectively consent to arbitration through their conduct in the proceedings themselves.
Like proceeding with the arbitration without objecting to jurisdiction based on the lack of a formal written agreement?
Exactly. And finally, Article 7.6 clarifies the common situation of incorporation by reference. It states that a reference in a contract to any document containing an arbitration clause constitutes an arbitration agreement in writing, provided that the reference is such as to make that clause part of the contract. This confirms that standard contract law principles on incorporation apply, ensuring clarity on how clauses in separate documents become part of the main agreement.
Okay, that's option I, keeping in writing, but defining it very broadly and technologically neutrally. What about option 2? It sounds even more radical.
Option 2 is indeed the more minimalist and arguably more radical approach. It simply defines arbitration agreement in paragraph 1, just like option I, but then it completely omits any explicit writing requirement, like paragraphs 2 through 6 of option 1.
So no form requirement at all. How is validity determined then?
Its theoretical foundation is straightforward. It relies entirely on the general contract law of the enacting state to determine the validity and enforceability of the arbitration agreement, including any form requirements that might exist under that general law. It essentially says, if it's a valid contract under our domestic contract law, it's a valid arbitration agreement, regardless of form, unless our general contract law imposes a specific form.
That's maximum flexibility, but potentially less predictable internationally if domestic contract laws vary widely.
That's the trade-off. Option 2 is the most permissive regarding form at the model law level, but its actual effect depends heavily on the underlying national contract law of the enacting state.
So comparing these two options, what's the bigger picture? What are the implications for legal professionals drafting or trying to enforce these agreements?
Both options share a common strategic aim: to significantly enhance the enforceability of arbitration agreements, particularly those concluded electronically, while crucially preserving compatibility with the enforcement regime of the New York Convention, especially its Article 2.2.
How did they maintain compatibility with the NYC, given the NYC's stricter original wording?
Largely through Article 7 of the NYC, the more favorable law provision, which we'll discuss in detail later. It essentially allows parties to rely on more liberal domestic rules, like those in the model law, if they help validate the agreement. Option I offers a pragmatic, harmonized solution for modern commerce by focusing on the recorded content, providing more certainty than purely oral agreements might. Option 2 offers maximum flexibility but might introduce less predictability if the enacting state's general contract law is unclear or variable regarding digital contracting or oral agreements.
So for practitioners,
For legal professionals, understanding which option 1 or option 2 an enacting state has adopted for its Article 7 is absolutely critical. It directly impacts how you assess the validity of an existing arbitration agreement, especially one formed electronically or informally, and strategically, it influences how you draft future arbitration clauses to ensure they are robust and enforceable across jurisdictions that might have adopted different options or haven't adopted the model law at all. These options really represent a necessary evolution, pushing against outdated formalities to reflect the realities of global business.
okay, now let's turn to the crucial interaction between a valid arbitration agreement and the courts. Articles 8 and 9 are foundational here, defining how courts should react when faced with a dispute that's subject to arbitration.
Yes, Article 8 lays down a cornerstone principle for this interaction, and it's directly modeled on Article 2 of the New York Convention, ensuring consistency. It establishes a mandatory obligation on national courts.
That's the obligation.
It states that a court before which an action is brought in a matter which is the subject of an arbitration agreement shall, if a party so requests not later than when submitting his first statement on the substance of the dispute, refer the parties to arbitration.
So the default is hands off, send it to arbitration.
Exactly. The court must refer them unless, and this is the limited exception, it finds that the agreement is null and void, inoperative, or incapable of being performed.
That sounds like a very strong presumption in favor of arbitration. What are the practical implications for litigants?
It's a powerful statement of pro-arbitration policy. It ensures that courts respect the party's choice to arbitrate and prevents parties from easily bypassing their agreement by starting parallel litigation in court. The exceptions, null and void, inoperative, or incapable of being performed, are intended to be interpreted narrowly, covering situations where the agreement fundamentally fails, maybe due to lack of consent, or the dispute isn't arbitrable, or performance is physically impossible.
And the timing is important too. The request has to be made early in the court proceedings.
Yes, not later than when submitting his first statement on the substance of the dispute. This prevents parties from waiting to see how the court case is going before playing their arbitration card. Critically, Article 8(2) adds a vital practical element. Even while the court is considering this jurisdictional challenge, the arbitral proceedings may nevertheless be commenced or continued, and an award may be made.
So the court challenge doesn't automatically freeze the arbitration.
Correct. This is a crucial safeguard against dilatory tactics. A party can't simply file a court challenge to the arbitration agreement just to stall the arbitration indefinitely. It places the burden of proving the agreement's invalidity squarely on the party resisting arbitration and allows the arbitral process to maintain momentum.
Got it. Now, Article 9 clarifies something that used to be a point of contention in some jurisdictions: the compatibility of seeking interim measures from a court with the existence of an arbitration agreement. Why was this clarification needed?
Article 9 addresses a potential misunderstanding. It clarifies a vital point. It is not incompatible with an arbitration agreement for a party to request interim measures of protection from a court. Think pre-award attachments, injunctions to preserve the status quo, either before the arbitration starts or during the arbitral proceedings. And equally, it's not incompatible for a court to grant such measures.
So, going to court for urgent help doesn't mean you've waived your right to arbitrate.
Exactly. Historically, in some legal systems, seeking any kind of court intervention might have been seen as abandoning the arbitration agreement. Article 9 explicitly refutes that notion. It pragmatically acknowledges that sometimes parties need urgent help from a court to protect the subject matter of the dispute or secure assets, especially before an arbitral tribunal is fully constituted and empowered to act, or even alongside the tribunal's own powers.
It underscores the court's supportive role then.
Precisely. This provision underlines the supportive, rather than supervisory or undermining role that courts can play in maintaining the effectiveness of international arbitration, ensuring that assets or evidence aren't dissipated while the arbitration gets underway.
This brings us neatly to Part 4, actually managing the arbitration once that agreement is in place and being respected. Let's begin with the composition of the arbitral tribunal itself. covered in Chapter 3 of the Model Law, Articles 10 to 15.
Right. Chapter 3 is all about ensuring that arbitral tribunals can be constituted efficiently, fairly, and in line with the parties' intentions. It strikes that characteristic model law balance between maximizing party autonomy, the absolute cornerstone of arbitration, and providing a clear set of default rules backed by a judicial safety net to prevent deadlocks and ensure the process actually moves forward.
So starting with the basics, the number of arbitrators. Do parties get to choose?
Absolutely. Party autonomy reigns supreme here. Article 10(1) states very clearly, the parties are free to determine the number of arbitrators. They can choose 1, 3, 5, any number they agree on.
But what if they don't agree or their contract is silent on the number?
That's where the sensible default rule kicks in. Article 10(2) provides that if the parties fail to agree, the number of arbitrators shall be 3. 3 is often seen as a good balance for international disputes, allowing for diverse perspectives while remaining manageable.
Okay, and what about the procedure for actually appointing these arbitrators? Again, party choice first.
Yes, Article 11(2) follows the same principle. The parties are free to agree on a procedure of appointing the arbitrator or arbitrators. They can name them directly, specify required qualifications, designate an appointing authority like an arbitral institution, ICC, LCIA, etc., or devise any other mechanism they see fit.
But appointing arbitrators is often where things can get stuck, isn't it? What happens when parties can't agree on a sole or presiding arbitrator, or one party simply refuses to nominate their arbitrator? That's where the default rules and that judicial safety net become critical, right?
Indeed, this is a classic potential bottleneck, and the model law provides robust mechanisms to overcome it. Article 11(3) lays out default procedures. For a 3-arbitrator tribunal, the default is each party appoints 1 arbitrator, and those 2 party-appointed arbitrators then appoint the 3rd, the presiding arbitrator.
And if they get stuck, say that 2 party-appointed arbitrators can't agree on the chair.
That's where the safety net the court specified in Article 6 steps in. Under Article 11(3), if the 2 arbitrators fail to agree on the 3rd within 30 days of their appointment, or if the parties fail to agree on a sole arbitrator within 30 days of a request, any party can request the Article 6 court or other designated authority to make the necessary appointment.
So the court acts as a last resort, a mechanism to ensure the tribunal actually gets formed and the arbitration doesn't stall indefinitely at the starting gate.
Exactly. Articles 11, 4, and 5 reinforce this judicial safety net. If an agreed-upon appointment procedure fails for any reason, maybe a party simply fails to act as required, or a designated institution doesn't perform its function, or the party's arbitrators just can't reach agreement, any party can request the Article 6 court to intervene and take the necessary measure, like making the appointment itself.
And the court's decision in these appointment matters is final.
Yes, crucially, any decision by the designated court on these appointment matters shall be subject to no appeal. This prevents further tactical delays through appeals. When making an appointment, the court is guided by several factors. It must consider any qualifications agreed upon by the parties, ensure the appointee's independence and impartiality, and particularly for a sole or presiding arbitrator, consider the advisability of appointing someone of a nationality different from the parties' nationalities to enhance neutrality.
It seems like a well-designed system balancing party control with mechanisms to prevent obstruction.
It aims to be, yes. It gives parties every chance to form the tribunal themselves, but provides a default path and judicial backstop if they can't or won't.
Okay, so the tribunal is appointed. But what if circumstances arise later that cast doubt on an arbitrator's impartiality or independence? Let's talk about challenges, the grounds, and procedure under Articles 12 and 13.
This is fundamental to the integrity of the process. Article 12(1) establishes a crucial, ongoing ethical obligation for arbitrators. From the moment they are approached about a potential appointment and throughout the entire proceedings, they shall disclose any circumstances likely to give rise to justifiable doubts as to his impartiality or independence.
So it's not just a one-time check at the beginning.
No, it's a continuing duty. If new circumstances arise mid-arbitration, they must be disclosed. Article 12(2) then sets out the grounds upon which an arbitrator can actually be challenged. First, if circumstances exist that give rise to justifiable doubts as to his impartiality or independence, or second, if he does not possess qualifications agreed to by the parties.
What does justifiable doubts mean? Is that a high bar?
It's an objective standard. It's not based on the subjective feeling of the challenging party, but whether a reasonable third person, knowing all the relevant facts, would be likely to conclude there's a real possibility of bias. It's meant to be a serious standard, balancing the need for integrity with preventing frivolous challenges. There's also a key nuance for practitioners in 12.2. A party can only challenge an arbitrator they themselves appointed or participated in appointing for reasons they become aware of after that appointment was made.
Okay, makes sense. And the challenge procedure itself, does it go straight to court or is it handled within the arbitration first?
The model law again prioritizes party autonomy and internal resolution first. Article 13.1 allows parties to agree on their own challenge procedure. If they haven't agreed on one, Article 13.2 provides the default. The challenging party must send a written statement outlining the reasons for the challenge to the arbitral tribunal itself, typically within 15 days of becoming aware of the tribunal's constitution or the specific circumstance giving rise to the doubt.
So the tribunal gets the first look.
Yes. The challenged arbitrator might withdraw, or the other party might agree to the challenge. If neither happens, the arbitral tribunal, including the challenged arbitrator, interestingly decides on the challenge.
What if the tribunal rejects the challenge, but the challenging party is still convinced there's a genuine issue of bias or lack of qualification?
That's where the judicial review safety net comes in again, but only after the internal procedure has failed. If the challenge is unsuccessful under the agreed procedure or the default procedure where the tribunal decides, the challenging party can then, within 30 days of receiving notice of that rejection, request the Article 6 court to decide on the challenge.
And that court decision is final.
Again, yes, the court's decision on the challenge itself is subject to no appeal. But here's a critically important point for efficiency found in Article 13.3. While such a request to the court is pending, the arbitral tribunal, including the challenged arbitrator, may continue the arbitral proceedings and make an award.
Wow. So the arbitration doesn't automatically stop just because a challenge is being reviewed by the court?
Correct. This is a major safeguard against challenges being used purely as a dilatory tactic to derail or delay the arbitration. It allows the process to keep moving forward unless the court specifically orders otherwise, which it might do in exceptional cases.
That dynamic is fascinating, constantly balancing due process rights with the need to prevent obstruction and maintain efficiency. And finally, under this chapter, what happens if an arbitrator becomes genuinely unable to perform their functions, maybe due to illness, or they simply fail to act without undue delay? Articles 14 and 15 cover this.
Yes, Articles 14 and 15 provide clear rules for the termination of an arbitrator's mandate and their replacement. If an arbitrator becomes de jure by law or de facto, in fact, unable to perform his functions, or for other reasons fails to act without undue delay, their mandate terminates automatically if they withdraw or if the parties agree on termination.
And if there's disagreement about whether they are unable to act?
Then, under Article 14.1, if controversy remains, any party can request the Article 6 court to decide on the termination of the mandate, and again, that court decision is not appealable. Article 14.2 clarifies that if an arbitrator withdraws or a party agrees to termination under this article, it does not imply acceptance of the validity of any grounds mentioned. Article 15 then logically provides that when an arbitrator's mandate terminates for any of these reasons, or challenge, withdrawal, etc., a substitute arbitrator shall be appointed according to the rules that were applicable to the appointment of the arbitrator being replaced. This ensures consistency in the appointment process and maintains the legitimacy of the reconstituted tribunal.
Okay, moving on to Chapter 4, and a truly cornerstone concept in international arbitration, something legal professionals often refer to by its German name, competence. This is the tribunal's power to rule in its own jurisdiction, right? Article 16 is the key provision here.
Competence is, without exaggeration, a foundational principle underpinning the autonomy and effectiveness of the entire arbitral process. Article 16.1 states it clearly. The arbitral tribunal may rule on its own jurisdiction, including any objections with respect to the existence or validity of the arbitration agreement.
Why is this so important? What would happen without it?
Think about the alternative. Without competence, a party who simply wanted to obstruct the arbitration could easily derail it right at the start by running off to a national court and challenging the validity of the arbitration agreement. The entire process would grind to a halt pending potentially lengthy court proceedings.
So competence allows the tribunal itself to be the first instance decision maker on whether it has authority.
Exactly. It empowers the tribunal to say, hold on, let us decide first whether we have jurisdiction based on the agreement the parties signed. This is fundamental to arbitration's independence from excessive court interference and crucial for its efficiency.
And closely tied to this is the principle of separability, or the autonomy of the arbitration clause. How does Article 16 address that?
This is also enshrined in Article 16.1 and is equally powerful and practical. The principle states that an arbitration clause which forms part of a contract shall be treated as an agreement independent of the other terms of the contract.
Meaning the arbitration clause has its own life, separate from the main contract.
Precisely. The huge practical implication for practitioners comes next. A decision by the arbitral tribunal that the main contract is null and void shall not entail ipso jure by operation of law the invalidity of the arbitration clause.
So even if the main contract is found to be completely invalid, perhaps it was induced by fraud or void for illegality, the arbitration clause itself can still survive.
Yes, typically it survives. This doctrine prevents the baby being thrown out with the bathwater. It ensures that the tribunal, established under the arbitration clause, retains the power to decide disputes arising out of the contract, including disputes about the validity of the main contract itself. Without separability, finding the main contract void could paradoxically invalidate the very mechanism chosen by the parties to resolve such disputes.
That's a critical doctrine for making arbitration work. Now, what about the timing for raising these jurisdictional objections? Can a party wait until the end of the case to suddenly claim the tribunal never had jurisdiction?
No, the model law imposes strict timing rules in Article 16.2 precisely to prevent such ambush tactics and promote procedural efficiency. A plea that the arbitral tribunal does not have jurisdiction must be raised not later than the submission of the statement of defense.
So right at the beginning, essentially.
Yes, and a plea that the tribunal is exceeding the scope of its authority, perhaps, by deciding on an issue not covered by the arbitration agreement, must be raised, quote, as soon as the matter alleged to be beyond the scope of its authority is raised during the arbitral proceedings.
And if a party misses these deadlines?
Failure to raise the objection promptly is generally considered a waiver of the right to object later, both before the tribunal and potentially before a court during setting aside or enforcement proceedings. However, the tribunal does retain discretion. It may admit a later plea if it considers the delay justified by truly compelling circumstances.
Okay, so the tribunal rules on its jurisdiction, potentially upholding it. What about court control over that decision? If the tribunal says, yes, we have jurisdiction, can a party immediately run to court to appeal that specific ruling, or do they generally have to wait for the final award?
This is where Article 16.3 strikes that careful balance between arbitral autonomy, competence, and necessary judicial oversight. The process depends on how the tribunal makes its jurisdictional ruling. If the tribunal rules on jurisdiction as a preliminary question, meaning it issues a separate preliminary decision confirming its jurisdiction before diving deep into the merits, then Article 16.3 allows any party within 30 days of receiving notice of that ruling to request the Article 6 court to decide the matter.
So there is a possibility for immediate court review in that specific scenario.
Yes, but with crucial safeguards against delay built in. First, the court's decision on this preliminary jurisdictional question is subject to no appeal, providing finality at that judicial level. Second, and critically, while such a request is pending before the court, the arbitral tribunal may continue the arbitral proceedings and make an award.
Again, preventing the court challenge from automatically paralyzing the arbitration.
Exactly. It maintains the momentum. Now, the alternative is that the tribunal might choose not to rule on jurisdiction as a preliminary question, but rather deal with it together with the merits in its final award. In that case, judicial review of the jurisdictional issue only becomes available later as part of the grounds for setting aside the final award under Article 34 or as a defense to recognition and enforcement under Article 36.
So the model law offers options, aiming to balance efficiency with ensuring fundamental jurisdictional challenges can eventually be reviewed by a court.
That's the goal, striking that delicate balance.
Now, let's talk about arguably the most significant single set of amendments introduced in 2006. The entirely new Chapter 4A, covering interim measures and preliminary orders. This dramatically expanded the arbitral tribunal's toolkit for providing urgent relief, didn't it?
It was an absolute game changer for the practical effectiveness of arbitration. This new chapter completely overhauled and replaced the much more limited single Article 17 from the 1985 model law. The new Article 17.1 now clearly and broadly states that unless the parties have agreed otherwise, the arbitral tribunal may, at the request of party, grant interim measures.
And what constitutes an interim measure? How is it defined?
Article 17.2 gives a broad definition. It's any temporary measure, whether in the form of an award or in another form, by which, at any time prior to the issuance of the final award, the tribunal orders a party to do one of several things. This explicit empowerment is a massive leap forward compared to the uncertainty that existed under many older national laws.
So what kinds of specific urgent relief can a tribunal now order under this expanded power? Can they, for instance, order a party to freeze assets to ensure a future award can be paid?
Yes, absolutely. The model law in Article 17.2 specifies four main categories or purposes of interim measures the tribunal can order a party to undertake.
Maintain or restore the status quo pending the determination of the dispute. Classic preservation.
Take action that would prevent or refrain from taking action that is likely to cause current or imminent harm or prejudice to the arbitral process itself. Think preventing evidence destruction.
Provide a means of preserving assets out of which a subsequent award may be satisfied. This is the asset preservation or freezing order type, hugely important in financial disputes.
Preserve evidence that may be relevant and material to the resolution of the dispute.
That's a comprehensive list. It really equips the tribunal to manage the dispute effectively from start to finish, not just issue a final judgment.
Exactly. It makes arbitration a much more robust and effective dispute resolution mechanism, capable of addressing urgent needs during the process, often much faster and potentially with more subject matter expertise than relying solely on national courts for such relief.
But granting these measures, especially things like asset freezes, is a significant intervention. What are the conditions? The tribunal can't just grant them automatically, surely. There must be safeguards.
Absolutely. The power comes with responsibility and clear conditions set out in Article 17A. These conditions deliberately mirror well-established principles found in many domestic court systems for granting injunctive or interim relief, providing a familiar framework. For most measures, categories A, B, and C, covering status quo, preventing harm prejudice, and asset preservation, the requesting party must satisfy the tribunal on three key points.
Okay, what are they?
First, that harm not adequately reparable by an award of damages is likely to result if the measure is not ordered, and that such harm substantially outweighs the harm that is likely to result to the party against whom the measure is directed if the measure is granted. It's a balance of hardships analysis.
Makes sense. Irreparable harm and balance of convenience. What else?
Second, there must be a reasonable possibility that the requesting party will succeed on the merits of the claim. It's not proof beyond doubt, but more than just a frivolous claim. The tribunal needs some confidence in the underlying case.
Okay, and the third?
The third condition relates to the urgency and purpose of the specific measure requested. Now, for evidence preservation measures, Category D, Article 17A2 provides more flexibility, stating these conditions apply only to the extent the arbitral tribunal considers appropriate. This acknowledges that the criteria might need adjustment when the goal is simply preserving evidence rather than, say, freezing assets.
So a clear framework, but with some built-in flexibility for the tribunal. Now let's get to the truly novel and frankly most talked about aspect of these 2006 amendments. Preliminary orders, covered in Articles 17B and 17C. This introduces an ex parte dimension into international arbitration, doesn't it? Meaning one party can seek an urgent order without the other party even knowing initially.
This is indeed the critical innovation, and one that generated considerable debate during the drafting process because of the due process implications. Article 17b1 explicitly allows a party, concurrently with requesting a regular interim measure, to also submit an application for a preliminary order directing a party not to frustrate the purpose of the interim measure requested. And this application can be made without notice to any other party.
Without notice. So if I understand correctly, this is designed for those situations where you have a genuine fear that if you notify the other side you're seeking, say, an asset freeze, they will immediately move the assets or destroy the evidence before the tribunal can even consider the main interim measure request.
Precisely that scenario. The tribunal may grant such a preliminary order under Article 17b2 only if it considers that prior disclosure of the request for the interim measure to the party against whom it is directed risks frustrating the purpose of the measure. It's a high threshold, focused squarely on the risk of dissipation or destruction if notice is given. The general conditions from Article 17a, harm, balance, merits, also apply, adapted to the context of the preliminary order itself.
This sounds incredibly powerful, potentially very useful in certain high-risk situations, but it immediately raises flashing red lights regarding fundamental due process acting without the other side even being heard. How does the model law address those core fairness safeguards?
That's where Article 17c, establishing the specific regime for preliminary orders, comes in with its carefully drafted mandatory procedural safeguards. UNCITRAL was acutely aware of the due process concerns. As soon as the tribunal has made a determination on the preliminary order application, whether granting or denying it, Article 17c1 mandates that it must give notice to all parties, including, crucially, the party against whom the order might be directed, of the initial request for the interim measure, the application for the preliminary order itself, if granted, and all other communications between the applying party and the tribunal related to it.
So the secrecy is strictly limited to the absolute minimum time needed for the tribunal to make an initial decision. It's not a prolonged ambush.
Exactly. The window of non-disclosure is very short and targeted. And immediately following that notification, Article 17c2 requires the tribunal to give the party against whom the preliminary order is directed an opportunity to present its case at the earliest practicable time.
So they get heard very quickly afterwards.
Yes. And the tribunal shall decide promptly on any objection raised against the preliminary order, Article 17c3. Furthermore, a preliminary order has a very limited lifespan. Article 17c4 states it shall expire after 20 days from the date it was issued. While the tribunal can issue a full interim measure after this period, having heard both sides, the initial ex parte bite is strictly time-limited.
20 days, that's quite short. And what about its enforceability? Can a party take a preliminary order straight to a national court for enforcement if the other side ignores it?
This is another crucial distinction and safeguard. Article 17c5 explicitly states that a preliminary order shall be binding on the parties but shall not be subject to enforcement by a court. Such a preliminary order does not constitute an award.
Not enforceable by courts. So its effectiveness relies on the party's compliance or the tribunal's persuasive authority during that 20-day period.
Largely, yes. It reflects a cautious, balanced approach. UNCITRAL created this powerful ex parte tool to address a real practical need, preventing frustration of relief, but deliberately limited its direct court enforceability and duration, and surrounded it with strict procedural safeguards, immediate notice, prompt hearing, to mitigate the inherent due process risks. It's a fascinating example of balancing competing needs.
It really is. Now, beyond the specifics of interim measures versus preliminary orders, there are also general provisions in Section 3, Article 17dg, that apply to both types of relief. What are these overarching rules for managing them?
Yes, these provisions add further layers of control and accountability. Article 17d confirms the tribunal's power to modify, suspend, or terminate an interim measure or a preliminary order it has granted, either upon application by a party or, in exceptional circumstances and after giving notice, on its own initiative. This allows adjustments if circumstances change.
Okay, flexibility. What about security? Can the tribunal require the requesting party to put up money as a condition?
Yes. Article 17e deals with the provision of security. For regular interim measures, the tribunal may require the requesting party to provide appropriate security. However, for preliminary orders, given their ex parte nature, the rule is stricter. The tribunal shall require security unless the tribunal considers it inappropriate or unnecessary to do so. This mandatory, unless accepted security requirement for preliminary orders is another key safeguard for the respondent.
And disclosure. Is there an ongoing duty to keep the tribunal informed?
Absolutely. Article 17F mandates disclosure. The tribunal may require any party to promptly disclose any material change in the circumstances based on which the measure was requested or granted. Crucially, the party applying for a preliminary order has an even higher ongoing duty. They must disclose to the tribunal all circumstances that are likely to be relevant to the tribunal's determination, and this duty continues until the party against whom the order is directed has had an opportunity to present its case. Full and frank disclosure is paramount in the ex parte context.
Makes sense. And what if it turns out the interim measure or preliminary order shouldn't have been granted? Is the requesting party liable for damages caused?
Yes, Article 17G addresses costs and damages. It explicitly states that the party requesting an interim measure or applying for a preliminary order shall be liable for any costs and damages caused by the measure or the order to any party if the arbitral tribunal later determines that, in the circumstances, the measure or the order should not have been granted. The tribunal can award such costs and damages at any point during the proceedings. This accountability mechanism acts as a significant deterrent against frivolous or abusive requests for interim relief.
So taken together, Articles 17D through G provide a robust system of checks and balances around these powerful interim tools.
They do. They ensure flexibility, require security where appropriate, especially for preliminary orders, demand ongoing disclosure, and impose liability for wrongly granted measures.
Now, arguably, the provision that gives real teeth to these arbitral interim measures is their recognition and enforcement by national courts. Section 4, Articles 17H and 70I seems to create a regime similar to that for final awards. That sounds like a truly significant practical advancement.
It is a massive step forward and arguably the centerpiece of the 2006 reforms in this area, truly empowering arbitral tribunals. Section 4 establishes a robust, dedicated regime for the recognition and enforcement of interim measures issued by arbitral tribunals. Article 17H1 lays down the core principle. An arbitral interim measure shall be recognized as binding and, unless otherwise provided by the arbitral tribunal, enforced upon application to the competent court, irrespective of the country in which it was issued.
Irrespective of the country, so truly international enforcement.
Yes, subject only to the limited grounds for refusal set out in Article 17I. This aims to put arbitral interim measures on a much stronger footing, making them far more effective than they often were pre-2006 when enforcement could be uncertain or dependent on ad hoc national rules.
Does the enforcing court have any conditions or discretion?
Article 17H2 requires the parties seeking enforcement to promptly inform the court of any termination, suspension, or modification of the interim measure by the tribunal. And Article 17H3 gives the enforcing court discretion. It may order the requesting party to provide appropriate security if the tribunal hasn't already addressed security or if the court deems security necessary to protect third parties. This allows the court to ensure fairness at the enforcement stage.
Okay, and what are the grounds for a court to refuse recognition or enforcement of these arbitral interim measures? Are they the same narrow grounds we see for refusing final awards under the New York Convention in Article 36?
Yes, Article 17I lists the grounds for refusal, and critically, they largely mirror the grounds found in Article 36 of the Model Law for Final Awards and Article V of the New York Convention. This ensures consistency.
So things like
The incapacity of a party, invalidity of the arbitration agreement, fundamental due process violations during the arbitral proceedings, like lack of proper notice or inability to present one's case, the measure dealing with a dispute beyond the scope of the submission to arbitration, or issues with the composition or procedure of the tribunal. There are also the familiar public policy and non-arbitrability exceptions tied to the law of the enforcing state.
And crucially, the court doesn't re-examine the merits of the interim measure itself.
That's explicitly stated in Article 17I2. The court where recognition or enforcement is sought shall not undertake a review of the substance of the interim measure. Its review is limited to these specific, primarily procedural grounds. This respect for the tribunal's decision-making on the merits is key to making the enforcement process efficient and predictable. This whole section dramatically enhances the utility of arbitral interim measures.
It really sounds like it. Finally, on interim measures, what about court-ordered ones? Does the model law still allow national courts to issue their own interim measures in support of arbitration, even if the arbitration is happening elsewhere?
Yes, the model law confirms this supportive role continues. Article 17J, which forms Section 5, explicitly states that a court shall have the same power of issuing an interim measure in relation to arbitration proceedings, irrespective of whether their place is in the territory of this state, as it has in relation to proceedings in courts, end quote. It also says the court shall exercise this power according to its own procedures, but considering the specific features of international arbitration.
So parties still have the option of going to a national court for interim relief if needed, perhaps because the tribunal isn't constituted yet, or if they need enforcement against a third party.
Exactly. Article 17J confirms that national courts retain this parallel power to provide supportive interim relief, even for arbitrations seated abroad, consistent with the exceptions to territoriality we discussed. It reinforces the idea that court intervention, when properly channeled and supportive, is entirely compatible with, and often essential for, the effectiveness of international arbitration.
Okay, let's transition now to Part 5. The actual conduct of the arbitration proceedings themselves, leading up to the making of the award and the termination of the proceedings. Chapter 5, Articles 18 to 27, is all about the conduct of arbitral proceedings. What are the absolute fundamental principles guiding how an arbitration should be run under the model law?
The overarching non-derogable principles are enshrined right at the start in Article 18. They form the bedrock of procedural fairness in any model law arbitration. The parties shall be treated with equality, and each party shall be given a full opportunity of presenting his case.
Equality and full opportunity. Sounds simple, but profoundly important.
Absolutely. This principle permeates and informs every other procedural rule in the chapter. It's the guiding star ensuring due process throughout the entire arbitration, regardless of the specific procedures chosen.
And in terms of determining those actual specific rules of procedure, it comes back to party autonomy again, doesn't it? The parties need to shape their own process to a large extent.
Yes, Article 19.1 grants parties very wide freedom in this regard. Subject to the provisions of this law, meaning the mandatory ones like Article 18, the parties are free to agree on the procedure to be followed by the arbitral tribunal in conducting the proceedings.
So they can choose institutional rules, ad hoc rules, modify rules.
Exactly. They can adopt established rules like the UNCITRAL rules, ICC rules, LCIA rules, or tailor-make their own bespoke procedure. This flexibility is absolutely crucial for international cases, allowing proceedings to be adapted to the specific nature of the dispute, the parties' legal or cultural backgrounds, and the type of evidence involved. It helps avoid the imposition of unfamiliar or unsuitable, rigid domestic procedural rules that might cause frustration or surprise for international participants.
But what if the parties haven't agreed on every single procedural detail, or they choose ad hoc arbitration without detailed rules? Does the tribunal just make it up as it goes along?
Not quite make it up, but Article 19.2 provides the necessary supplementary power. Failing agreement by the parties on specific procedural points, the arbitral tribunal may, subject to the provisions of this law, conduct the arbitration in such a manner as it considers appropriate.
So the tribunal has discretion to fill the gaps.
Yes, it has broad discretion to manage the process efficiently and fairly. This explicitly includes the power to determine the admissibility, relevance, materiality, and weight of any evidence. This power is particularly important in international arbitration, allowing tribunals to adopt flexible approaches to evidence, often blending common law and civil law traditions, without being strictly bound by the potentially restrictive evidentiary rules of any single national legal system.
Let's touch on some of the key specific procedural aspects covered. We already discussed the place of arbitration, Article 20, the legal seat being distinct from where hearings might actually occur.
Yes, Article 20 reiterates that parties are free to agree on the legal seat, and the tribunal determines it if they don't. But crucially, Article 22 confirms the tribunal can meet at any place it considers appropriate for hearings, consultations, or inspections, providing that vital logistical flexibility.
And when do arbitral proceedings officially commence under the model law? That seems like a clear trigger point.
Article 21 provides that clear trigger. Unless otherwise agreed by the parties, the arbitral proceedings in respect of a particular dispute commence on the date on which a request for that dispute to be referred to arbitration is received by the respondent. This establishes a clear, universally understood starting point, which can be important for things like statutes of limitation or procedural deadlines.
Language can obviously be a major issue in international cases. How does the model law handle that? Article 22.
Again, party autonomy first. Article 22.1 allows the parties to freely agree on the language or languages to be used in the proceedings. Failing such agreement, the arbitral tribunal determines the languages. This decision applies to all written statements by the parties, any oral hearings, and any award or other decision of the tribunal. Practical power is also given. The tribunal may order that any documentary evidence submitted be accompanied by a translation into the chosen language.
Makes sense. What about the core pleadings, the statements of claim and defense under Article 23? How detailed do they need to be?
Article 23 outlines the basic requirements. The statement of claim should state the facts supporting the claim, the points at issue, and the relief or remedy sought. The statement of defense should state the defense in respect of these particulars. Parties should generally submit all documents they consider relevant with their statements, or add a reference to the documents or other evidence they will submit. Flexibility is also built in. Unless the parties have agreed otherwise, either party may amend or supplement their claim or defense during the proceedings, unless the tribunal considers it inappropriate to allow such amendment having regard to the delay in making it. This balances the need for evolution of the case with procedural efficiency.
How does the model law approach the question of oral hearings versus proceedings conducted purely on the basis of documents? Article 24.
Article 24 gives the tribunal discretion, subject to party agreement. The tribunal decides whether to hold oral hearings for presenting evidence or oral argument, or whether the proceedings should be conducted solely on the basis of documents and other materials. However, this discretion is limited. Unless the parties have specifically agreed not to have oral hearings, the tribunal must hold such hearings at an appropriate stage if so requested by a party.
So a party generally has a right to an oral hearing if they want one.
Yes, that's a key due process safeguard. Article 24 also mandates fundamental fairness requirements for hearings and information exchange. Parties must receive sufficient advance notice of any hearing or meeting for inspection purposes. And critically, all statements, documents, expert reports, or other information supplied to the tribunal by one party shall be communicated to the other party. No secret submissions. Transparency is key.
What happens if a party simply defaults? Say, the claimant fails to submit their statement of claim, or the respondent just ghosts the proceedings and doesn't file a defense or show up for hearings. Can the arbitration still move forward effectively? Article 25.
Article 25, dealing with default of a party, is absolutely vital for the practical effectiveness of international arbitration, ensuring it can't easily be sabotaged by non-cooperation. It addresses several scenarios. If the claimant fails to communicate their statement of claim within the agreed or ordered time, the tribunal shall terminate the proceedings. Game over for the claimant in that arbitration.
Okay, but what if the respondent fails to communicate their statement of defense?
If the respondent fails to submit their defense, Article 25b states the tribunal shall continue the proceedings without treating such failure in itself as an admission of the claimant's allegations. The claimant still has to prove their case. The tribunal proceeds based on the evidence before it.
And if a party fails to appear at a hearing or produce requested documents?
Similarly, under Article 25c, if any party fails to appear at a hearing or fails to produce documentary evidence as requested, the tribunal may continue the proceedings and make the award on the evidence before it. These provisions ensure that arbitration can proceed to a conclusion even with an uncooperative party, upholding the necessary effectiveness of the process while still requiring the active party to meet their burden of proof based on evidence.
What about expert witnesses? Can the tribunal appoint its own expert, and how do the parties interact with tribunal-appointed experts? Article 26.
Yes, Article 26 gives the tribunal the power, unless otherwise agreed by the parties, to appoint one or more experts to report to it on specific issues the tribunal needs help determining. The tribunal can also require parties to provide the expert with relevant information or access to documents, goods, or property for inspection.
Do parties get to question tribunal's expert?
Yes. Critically, for due process, unless the parties have agreed otherwise, if a party requests it, or if the tribunal considers it necessary, the expert must, after delivering their written or oral report, participate in a hearing. At this hearing, parties have the opportunity to put questions to the expert and also to present their own expert witnesses to testify on the points at issue. This ensures a fair chance for scrutiny and rebuttal of the expert evidence.
Finally, in terms of conducting the proceedings, what kind of court assistance is available specifically for taking evidence? Does the model law rely solely on the tribunal's own powers, which might be limited when dealing with third parties? Article 27.
No, it realistically acknowledges the limits of purely arbitral power. Article 27 explicitly provides for court assistance in taking evidence. The arbitral tribunal itself, or a party with the tribunal's approval, can request assistance from a competent court in the enacting state in taking evidence. The court then executes the request within its competence and according to its rules on taking evidence.
So this is how you might compel a reluctant third-party witness to testify or obtain documents from someone not involved in the arbitration.
Exactly. This highlights a crucial area where judicial support is often necessary to aid the arbitral process, bridging the gap where the tribunal's own procedural orders might lack coercive effect against non-parties.
Okay, let's move on now to Chapter 6, the making of the award and termination of proceedings, Articles 28-33. Article 28, dealing with the rules applicable to the substance of the dispute, introduces a really significant point about party autonomy that goes beyond just choosing a national law.
Yes, Article 28 is remarkably modern and flexible in its approach to the substantive law governing the merits of the dispute. Article 28(1) starts with party autonomy. The arbitral tribunal shall decide the dispute in accordance with such rules of law as are chosen by the parties as applicable to the substance of the dispute.
Rules of law. Why that phrasing rather than just law?
That phrasing is deliberate and significant. It clarifies that parties are free to choose not only the national law of a specific state, for example, Swiss law, New York law, but also non-national sets of rules or principles, sometimes referred to as transnational law, lex mercatoria, or general principles of law.
So they don't have to pick a specific country's law. They could choose something like The UNITRAL principles of international commercial contracts to govern their contract dispute.
Exactly. Or they could choose principles of international law for an investment dispute, or perhaps specific industry rules. This moves beyond the limitations of traditional conflict of laws analysis that inevitably points to a national law. It grants parties significant autonomy to select a substantive legal framework they feel is most appropriate for their international transaction. Failing any such designation by the parties, Article 28(2 provides the default. The tribunal shall apply the law determined by the conflict of laws rules which it considers applicable. The tribunal chooses the conflicts rule.
And what about deciding a case based purely on fairness or equity, rather than strict legal rules? The concepts of ex equo et bono, or amiable compositur.
Article 28(3 addresses this directly. The tribunal can decide ex equo e bono, according to what is right and good, or as amiable compositur, as a friendly conciliator, looking for an equitable solution, only if the parties have expressly authorized it to do so.
So it requires explicit consent. The tribunal can't just decide to ignore the law on its own.
Absolutely not. It's a deviation from standard legal adjudication and therefore requires clear, unambiguous authorization from the parties. Finally, regardless of the chosen rules of law, Article 28(4 mandates that, in all cases, the arbitral tribunal shall decide in accordance with the terms of the contract and shall take into account the usages of the trade applicable to the transaction. This ensures the decision remains grounded in the parties' specific agreement and the relevant commercial context.
How are decisions actually made by a panel of arbitrators, say a standard panel of three? Does it require unanimity? Article 29.
Article 29 clarifies this. In proceedings with more than one arbitrator, any decision of the tribunal shall be made unless otherwise agreed by the parties by a majority of all its members. Unanimity is not required by default. However, the article adds a practical allowance for efficiency. Questions of procedure may be decided by the presiding arbitrator alone, if so authorized by the parties or by all members of the arbitral tribunal.
That makes sense for managing the day-to-day procedural issues. Now, what if the parties manage to reach a settlement during the arbitration? How does the model law handle that, and can that settlement gain the same enforceability as a contested award? Article 30.
Article 30 powerfully encourages and facilitates amicable resolution. If the parties settle their dispute during the arbitral proceedings, the tribunal terminates the proceedings. Importantly, if the parties request it and the tribunal does not object, the tribunal can record the settlement in the form of an arbitral award on agreed terms.
An award on agreed terms. What's the significance of that?
It's hugely significant, practically. Article 32 states that such an award has the same status and effect as any other award on the merits of the case. This means the settlement gets clothed with the authority and, crucially, the international enforceability, primarily via the New York Convention, of a regular arbitral award. It's a much stronger way to finalize a settlement than just a simple contractual agreement.
Okay, and the final award itself, the one deciding the merits after contested proceeding. What are the formal requirements for its form and contents under Article 31?
Article 31 sets out the key formal requirements. The award must be in writing and signed by the arbitrator or arbitrators. For panels with multiple arbitrators, the signatures of the majority are sufficient, provided that the reason for any omitted signature, for example, refusal, illness, is stated on the award. The award must also state its date and the place of arbitration. The legal seat, as determined under Article 20, this is important for enforcement and setting aside.
And what about the reasons for the award? Is a reasoned award always required, explaining the tribunal's thinking?
This is a critical point. Article 312 states, "The award shall state the reasons upon which it is based, unless the parties have agreed that no reasons are to be given, or the award is an award on agreed terms under Article 30. So reasoned awards are the default requirement.
Why is that important?
The requirement for reasoned awards significantly enhances transparency, allows parties to understand how the decision was reached, facilitates any potential, though limited, judicial review for setting aside, and can contribute, albeit indirectly, to the development of arbitral jurisprudence. It promotes accountability. Interestingly, the model law is notably silent on whether arbitrators can issue dissenting opinions if they disagree with the majority. It neither requires nor prohibits them, leaving that to party agreement or institutional rules or tribunal practice.
When are the arbitral proceedings formally terminated? Is it always with the final award? Article 32.
Article 32 clarifies that the proceedings are terminated by the final award, yes. But they can also be terminated earlier by an order of the arbitral tribunal in specific circumstances. A, if the claimant withdraws their claim, unless the respondent objects and the tribunal recognizes a legitimate interest in obtaining a final settlement. B, if the parties agree to terminate the proceedings, or C, if the tribunal finds that the continuation of the proceedings has for any other reason become unnecessary or impossible. The tribunal's mandate generally terminates along with the proceedings, subject only to the possibility of correction, interpretation, or additional awards under Article 33 and potential involvement in setting aside proceedings.
And finally, under this chapter, what limited post-award actions are available directly from the tribunal itself? Things like correcting errors, interpreting the award, or dealing with accidentally omitted claims. Article 33.
Article 33 provides a very limited, specific mechanism for the tribunal to revisit its award, primarily to fix minor issues without needing court involvement. Within 30 days of receiving the award, unless another period is agreed, a party can, with notice to the other party, request the tribunal A, to correct any errors in computation, any clerical or typographical errors, or any errors of similar nature, or B, if the parties have agreed, to give an interpretation of a specific point or part of the award.
So correction is standard, but interpretation requires prior party agreement.
Yes. The tribunal can also correct the clerical type errors on its own initiative within 30 days. Additionally, Article 33 addresses omitted claims. If claims were presented in the arbitration but inadvertently omitted from the award, a party can, within 30 days, request the tribunal to make an additional award covering those claims. The tribunal must make this additional award within 60 days if it considers the request justified. The tribunal can extend these time limits if necessary.
These seem like useful mechanisms for tidying up loose ends, avoiding unnecessary court challenges for minor issues, while still respecting the overall finality, res judicata, of the award.
Exactly. They allow for minor adjustments and clarifications, ensuring the award is accurate and complete, but they don't open the door to re-arguing the merits.
Now we arrive at the critical endgame. Part 6, Recourse Against and Enforcement of Awards. This is where the international enforceability promise of arbitration is tested. Article 34 establishes the concept of exclusive recourse against an award at the seat. What exactly does that mean for a party unhappy with the outcome?
This is a cornerstone provision for ensuring the finality and efficiency that parties seek in arbitration. Article 34(1) states, in very clear terms, recourse to a court against an arbitral award may be made only by an application for setting aside in accordance with paragraphs 2 and 3 of this article.
Only by an application for setting aside. What does that exclude?
It explicitly aims to exclude other forms of judicial review or recourse that might exist under various domestic procedural laws, such as full appeals on the merits of the case or appeals based on errors of law or fact made by the tribunal. The model law deliberately channels any challenge at the seat into this single specific procedure, an application to set aside the award.
So the court at the seat isn't supposed to relitigate the case or second-guess the arbitrators on the substance.
Absolutely not. The focus of the setting aside procedure is strictly on the legitimacy and procedural integrity of the arbitral process and the resulting award, not on whether the tribunal reached the correct decision on the merits. This preserves the parties' agreement to have their dispute finally decided by the arbitrators, not the courts.
And there's a strict time limit for bringing this setting aside application.
Yes, a very strict one. Article 34(3) mandates that the application may not be made after 3 months have elapsed from the date the party making the application received the award, or if a request was made under Article 33 for a correction, interpretation, or additional award, from the date that request was disposed of by the tribunal.
3 months. That's a tight window, emphasizing finality.
It is. It ensures predictability and prevents challenges lingering indefinitely. It's also crucial to note that this Article 34 procedure is about a direct attack on the award, seeking to invalidate it at the seat of arbitration. It doesn't prevent a party from raising the same underlying grounds later as a defense if the winning party tries to enforce the award in another country under Article 36.
Okay, so what are these exhaustive grounds for setting aside listed in Article 34, its closed list, which provides crucial certainty, right?
It's an exhaustive closed list, and that clarity is invaluable for practitioners advising clients on potential challenges. These grounds, importantly, are deliberately designed to essentially mirror those found in Article 36 of the Model Law for refusing enforcement, and, critically, Article V of the New York Convention. This alignment creates a largely consistent global standard for both challenging and enforcing international awards.
So what are the grounds? They fall into 2 categories.
Yes, 2 main categories. First, Article 34(2)(a) lists grounds that the party making the application must prove. 1. Incapacity of a party to the arbitration agreement or the invalidity of the arbitration agreement itself. Under the law the parties chose, or failing that, the law of the enacting state, the seat. 2. Lack of proper notice of the appointment of an arbitrator or of the arbitral proceedings, or that the party was otherwise unable to present its case, a fundamental due process violation. 3. The award deals with a dispute not contemplated by or not falling within the terms of the submission to arbitration, or contains decisions on matters beyond the scope of this submission. Though if the problematic parts can be severed, the rest of the award may survive. 4. The composition of the arbitral tribunal or the arbitral procedure was not in accordance with the agreement of the parties, unless that agreement conflicted with a mandatory provision of the model law, or, failing such agreement, was not in accordance with the model law itself.
Okay, those seem focused on the agreement, due process, scope, and procedure. What's the second category of grounds, the ones the court can raise itself?
These are in Article 34.2, and the court can consider them even if the parties don't specifically argue them. They relate to fundamental issues of the state's own legal order. 1. The court finds that the subject matter of the dispute is not capable of settlement by arbitration under the law of this state, i.e. the law of the seat. This is the non-arbitrability ground. Some disputes, like certain criminal or family matters, might be reserved exclusively for national courts. 2. The court finds that the award is in conflict with the public policy of the state.
Ah, the public policy exception. That always raises questions, as public policy can be interpreted very broadly in domestic law. How is it generally understood in the specific context of setting aside international arbitral awards under the model law?
This is a critical point of interpretation for courts and practitioners. While the term isn't defined in the model law, the overwhelming international understanding, reflected in the drafting history and subsequent case law in model law jurisdictions, is that the public policy exception should be construed narrowly. It's generally limited to violations of the most basic notions of morality and justice of the forum state, or serious departures from fundamental notions of procedural justice.
So it's not an invitation for the court to review the merits or correct errors of law or fact made by the tribunal.
Definitely not. It's reserved for truly exceptional cases where upholding the award would violate the most fundamental principles of the legal system at the seat. For example, an award obtained through bribery or fraud, or one that fundamentally denies a party the right to be heard. This narrow interpretation is essential to maintain the distinction between appeal and setting aside, and to uphold the finality of arbitration.
Got it. Now, there's a very interesting and unique provision tucked away in Article 34 that allows the court, when asked to set aside an award, to potentially suspend the setting aside proceedings instead. What's the purpose of that? It sounds like a cure mechanism.
It is exactly that, a unique and highly practical cure or remittal mechanism. Article 34.4 provides that the court, when faced with a setting aside application, may, where appropriate and so requested by a party, suspend the setting aside proceedings for a period of time it determines.
And the purpose of hitting pause?
The explicit purpose is to give the arbitral tribunal an opportunity to resume the arbitral proceedings or to take such other action as in the arbitral tribunal's opinion will eliminate the grounds for setting aside.
So if the problem is, say, a procedural irregularity that the tribunal could potentially fix, the court can send it back to the tribunal to try and fix it, rather than just annulling the whole award.
Precisely. It allows for the possibility of curing certain defects, perhaps inadequate reasoning on a key point, or a procedural step that was missed without completely invalidating the entire award and forcing the parties to start all over again. This provision strongly promotes efficiency and finality, saving time and costs, by favoring cure over cancellation where possible. It's a very pragmatic feature.
It really is. Okay, let's move to the flip side of recourse. Recognition and enforcement of awards, covered in Chapter 8, Articles 35 and 36. This is about making the award actually count in practice, potentially in countries other than the seat. Article 35 introduces a really important policy decision regarding the uniform treatment of awards. What does that entail?
Yes. Article 35.1 reflects a significant policy choice embedded in the model law. It aims to treat arbitral awards, irrespective of the country in which it was made, uniformly for the purposes of recognition and enforcement within the enacting state. It deliberately blurs the traditional distinction between foreign awards made outside the enforcing state and domestic awards made within the enforcing state, at least for awards falling under the model law's definition of international.
Why move away from that seemingly intuitive foreign versus domestic distinction for enforcement?
The rationale, as explained in the Travaux Preparatoires and the explanatory note, is rooted in the realities of international arbitration practice. As we discussed, the place of arbitration, the legal seat, is often chosen for reasons of neutrality, convenience, or the quality of its arbitration law, and may actually have little or no connection with the parties, the dispute substance, or where assets are located.
So basing enforcement rules solely on whether the award was technically made domestically or foreign
Right.
seemed arbitrary in the international context.
Exactly. It could lead to differential treatment of awards arising from fundamentally similar international transactions just based on the seat's location. The model law's approach ensures that all international awards, whether technically foreign or domestic to the enforcing state, provided that state has enacted the model law, are subject to the same simple recognition and enforcement procedure laid out in Article 35 and the same limited grounds for refusal listed in Article 36. The core rule is awards falling under the model law shall be recognized as binding, and, upon application in writing to the competent court, shall be enforced subject to the provisions of this article and of Article 36.
Streamlined and uniform. And what about the procedural conditions for applying for enforcement under Article 35(2)? Were these also simplified in the 2006 amendments, perhaps mirroring the changes to Article 7 on the arbitration agreement?
They were indeed liberalized in 2006, reflecting that same practical, modernizing spirit. The party relying on an award and applying for its enforcement now shall supply the duly authenticated original award or a duly certified copy thereof. If the award isn't in an official language of the enforcing state, the court may request the party to supply a duly certified translation.
What's missing there compared to the New York Convention's requirements?
The key change, and a significant simplification for practitioners, is that unlike Article 4 of the 1958 New York Convention, presentation of the original or a certified copy of the arbitration agreement is no longer required under Article 35(2) of the model law as a condition for seeking enforcement.
Reflecting the liberalization of the form requirements for the agreement itself back in Article 7.
Precisely. It aligns the enforcement procedure with the modernized approach to the agreement's form. The explanatory note also points out that these streamlined conditions in Article 35(2) should be seen as maximum standards, meaning enacting states are free to adopt even less onerous conditions if they wish, further facilitating enforcement.
Okay, so enforcement is generally straightforward, unless one of the grounds for refusal in Article 36 applies. Are these grounds for refusing recognition or enforcement essentially the same exhaustive list we just discussed for setting aside an award under Article 34?
Yes, exactly. And this alignment is one of the model law's greatest strengths for promoting international consistency. The grounds for refusing recognition or enforcement listed in Article 36(1) are identical to those listed in Article V of the New York Convention and, as we saw, Article 34(2) of the model law.
So briefly, they cover
They cover the same territory. A. Grounds proven by the party resisting enforcement, like party incapacity or invalidity of the arbitration agreement, under the law applicable to it or the law of the seat. Fundamental due process violations, lack of notice, inability to present case. The award exceeding the scope of submission, or irregular composition or procedure of the tribunal, under party agreement or the law of the seat. And critically, Ground A allows refusal if the award has not yet become binding on the parties or has been set aside or suspended by a court in the country where or under the law of which that award was made, i.e. usually the seat.
And the court can also refuse on its own initiative based on non-arbitrability or public policy of the enforcing state.
Correct. Article 36(1)(b) contains those two grounds related to the law and public policy of this state, the state where recognition and enforcement is sought. 1, the subject matter is not arbitrable under its laws, or 2, the recognition or enforcement of the award would be contrary to its public policy.
And again, that public policy ground here in the enforcement context is generally interpreted narrowly, just like in the setting aside context.
Yes, the principle of narrow construction applies equally here. International comity and the pro-enforcement bias of the New York Convention and the model law dictate that refusal on public policy grounds should be reserved for violations of the most fundamental principles of justice in the enforcing jurisdiction, not mere errors of law or fact. This alignment of grounds across, setting aside Article 34, enforcement Article 36, and the New York Convention Article V, creates a remarkably coherent and predictable international framework.
It really does simplify the landscape. Finally, Article 36(2) allows the enforcing court to potentially adjourn its decision on enforcement if a setting-aside application is pending back at the seat. Can you explain that?
Yes. This provision addresses the scenario where an award is simultaneously being challenged at the seat under Article 34 and presented for enforcement elsewhere under Article 3-536. If an application for setting aside or suspension of the award has been made to the competent court at the seat, the court where enforcement is sought may, if it considers it proper, adjourn its decision on enforcement.
So it can wait and see what happens at the seat.
It can choose to wait. And importantly, the enforcement court may also, on the application of the party seeking enforcement, order the other party, the one challenging the award, to provide suitable security. This protects the award creditor in case the challenge at the seat fails, but the award debtor's assets have disappeared in the meantime. It's another pragmatic mechanism balancing fairness, finality, and security during the potentially overlapping post-award phases.
Our deep dive wouldn't be quite complete without touching on UNCITRAL's broader impact beyond the model law text itself, particularly the recommendation regarding the interpretation of the New York Convention that was adopted alongside the 2006 model law amendments. This seems quite significant.
Yes, it's very significant and shouldn't be overlooked. It's a testament to UNCITRAL's ongoing role, not just in creating new legal instruments, but also in promoting the uniform interpretation and application of existing crucial conventions like the NYC. This recommendation specifically addresses interpretation issues that had arisen concerning the convention, particularly in light of the model law's own modernization.
What issues did it target?
It explicitly acknowledges the differing interpretations of the form requirements of Article 2 of the New York Convention, the in-writing requirement we discussed, and directly links this to the widening use of electronic commerce. It also explicitly cross-references the updated Article 7 of the model law and other UNCITRAL instruments on electronic commerce, showing a deliberate effort to create coherence across its body of work.
So what does this recommendation actually recommend that courts do when applying Article 2, Paragraph 2 of the New York Convention regarding the form requirement for arbitration agreements?
The core principle is stated quite directly. UNCITRAL recommends that Article 2, Paragraph 2 be applied, recognizing that the circumstances described therein are not exhaustive.
Not exhaustive. What does that mean practically?
Remember, Article 2 of the NYC, drafted in 1958, had that specific list. An arbitral clause in a contract or an arbitration agreement signed by the parties or contained in an exchange of letters or telegrams. The recommendation encourages courts not to treat that list as rigidly closed. It suggests they should interpret Article 2 flexibly to accommodate newer forms of communication, particularly electronic ones, that clearly evidence the parties' consent to arbitrate, even if they don't fit neatly into the letters or telegrams box.
So this is UNCITRAL providing an authoritative interpretation, essentially guiding courts to read the 1958 Convention in light of 21st century realities, without needing a formal amendment to the treaty itself.
Exactly. It's an important interpretative guideline, an influential nudge from the body that also drafted the model law, aimed at preventing courts from refusing enforcement of perfectly valid arbitration agreements and subsequent awards based on an overly literal and outdated reading of the NYC's form requirement. It implicitly allows national courts enforcing NYC awards to adopt a more flexible approach, consistent with the spirit of the model law's modern Article 7, promoting global enforceability.
Very useful.
Yeah.
And the recommendation also addresses Article 7, Paragraph 1 of the New York Convention, the famous more favorable law provision. How does it clarify the application of that?
This clarification is also crucial for practitioners. Article 7 of the NYC basically says that the convention doesn't stop a party from relying on any more favorable rights they might have under the domestic law or other treaties of the country where enforcement is sought. It's a pro-enforcement provision.
Right, allowing use of more liberal local rules if they help.
Precisely. The UNCITRAL recommendation clarifies that this more favorable law provision should be applied not just to the enforcement of the award itself, but also to allow any interested party to avail itself of rights it may have under local law or treaties to seek recognition of the validity of the arbitration agreement itself.
So the more favorable law escape hatch applies to validating the agreement too, not just enforcing the final award. That's a significant clarification.
It is very significant. It means if a national law, perhaps one based on Model Law Option 2 with no form requirement, or another treaty applicable in the enforcing country has a more liberal rule on the form or validity of an arbitration agreement than the NYC's Article 2, a party can rely on that more favorable local law to uphold the agreement's validity, even if it might arguably fail under a strict reading of Article 2 alone.
That gives parties seeking to uphold arbitration agreements another potential avenue, leveraging progressive local laws.
Exactly. It empowers parties seeking enforcement and further harmonizes the landscape by effectively allowing the liberalized standards, like those found in the Model Law's Article 7, to be read into the application of the New York Convention via Article 7. It shows the dynamic and complementary relationship between these key international instruments.
What a truly comprehensive journey we've taken today through this foundational piece of law. We've really explored the UNCITRAL model law, especially focusing on those critical 2006 amendments. We've uncovered its deep commitment to uniformity, to party autonomy, and to establishing that carefully defined yet absolutely crucial supportive role for national courts.
We really have. We've seen how it brilliantly modernized the very definition of arbitration agreements to keep pace with the realities of global commerce. How it provided that robust, multi-layered framework for intermeasures, including those fascinating novel ex parte preliminary orders, and how it streamlined the recognition and enforcement of awards, aiming to align these vital processes globally for much greater predictability and efficiency.
Our goal throughout this deep dive was genuinely to enhance your understanding as legal professionals, to improve your practical competency when dealing with these issues, and maybe sharpen that critical legal reasoning by dissecting the underlying assumptions, evaluating legal consistency, and exploring the real-world applications of this vital framework.
And looking forward, as international commerce continues its relentless evolution, driven now by emerging technologies like blockchain, potentially underpinning smart contracts, or even AI playing a role in drafting and potentially resolving disputes, you have to wonder what will be the next frontier for international arbitration law.
That's the provocative thought, isn't it? How will frameworks like the UNCITRAL model law continue to adapt? How can they ensure they remain relevant, robust, and capable of facilitating justice in a truly globalized, increasingly digital economy, all while maintaining that incredibly delicate yet essential balance between the autonomy parties crave and the necessary judicial oversight that guarantees fairness and enforceability? Something for all of us in the field to keep thinking about.